Okay.
Welcome to another episode of the Biuletyn blog. Today our guest is Ms. Tatyana Slipachuk. Tatyana, I hope I pronounce your surname correctly. And unfortunately, I don't speak Ukrainian. And this episode will be the first, actually, it will be the first English-speaking episode of this blog. So thank you for accepting the invitation. And well, I would say that you are making history by becoming the first person interviewed in English on this blog. Before we start, maybe I should briefly introduce Tatyana. Tatyana was a partner at Sayenko-Karenko. Do I pronounce it correctly?
Yes.
So she was a partner at Sayenko-Karenko from 2011 until her appointment as chair of the Central Election Commission of Ukraine in 2018. She served as chair of this commission until 2019, and to my understanding, she has currently come back to private sector and works as special advisor at Sayenko-Karenko law firm. Of course, Tatyana has profound experience in arbitration, international dispute resolution. She took part in different roles in over 370 arbitrations in many jurisdictions. She's a chartered arbitrator, and also she also has achievements in the area of democracy promotion. Among other activities, she has served, for example, as of counsel at Chief Legal Department of the Ukrainian Parliament. Tatyana, is there anything I should add to this brief introduction of your person?
Thank you, Konrad. It's okay. I'm happy to hear the basic maybe points of my career. And you are right. I'm with the international arbitration for more than 28 years already. And I'm also, maybe the only thing I would like to add that my personal relations with the Polish Center is also very long lasting. And when I've been the Secretary General and when we established the court in Ukraine and had to start our international communication, so Professor Shursky was maybe one of the first who joined our community and assisted a lot in establishing the international position and relations of the International Arbitration Court attached to the Ukrainian Chamber of Commerce and Industry. So I'm really happy to be now with you and look forward to our discussion.
Mm-hmm. The main idea, as you know, behind our conversation, Solidarity, Arbitration and Mediation Days held in Warsaw, Poland from 16th to 18th November. However, on the occasion of this meeting, I would also like to ask some other questions about arbitration in Ukraine, more general questions. So I suggest to divide our conversation into two blocks. And first, let's talk about Solidarity, Arbitration and Mediation Days. Especially, let's talk about the concept behind this conference. Could you please present the idea behind the conference?
Yes, thank you. It's really, I believe, one unique situation because the idea and the background of this conference is a mixture of first of all, the real need for the Central European countries to have such type of the conference to embrace the issues being extremely relevant for the international arbitration and dispute resolution in the Eastern Europe. And on the other hand, it has this very close and very important for us, the Ukrainian idea, which is not only related to this extremely harmful and abnormal situation with the war, which caused a lot of deaths and disruptions in Ukraine and all over the Europe as well. But it also is connected with the situation that this year was a very specific for the Ukrainian arbitration. It was the year of the 30th anniversary. So the court was established 30 years ago. And this summer, we were planning a huge conference to take part in Kiev with the invitation of all our friends and colleagues to celebrate this very interesting data, because 30 years for the institution, it's still use, and we were going to exchange to inform about our achievements, our plans, etc. So I do believe that because of these things, this conference is based on a very friendly and professional relations between two institutions and, in principle, the states. And I'm really thankful to Rafał Morek and to the Court of Arbitration of the Polish Chamber of Commerce and Industry to push this idea, because for us it was very difficult to switch from our internal situation to the normal life, but we appreciate this possibility, and I believe that it will be interesting and in line with the major arbitration events happened during this autumn in all over the world.
Mm-hmm. So who came up with the idea to organize this conference?
The initiative was from the Polish side, and it was really accepted with gratitude, because for us, as I told, there's a nice possibility to speak about the court, to speak about the process we have in Ukraine, about the challenges also occurred in the sphere of international commercial arbitration for providing, administrating, how the parties deal with all these, and what are the material problems in the sphere of international public law, and how sanctions also influence the process in Ukraine. So it's a good possibility, because now we do not have these physical opportunity to have such sort of the conference still in Kiev because of the real danger, and so this is a live event which we're really looking for.
Mm-hmm. And could you briefly introduce the conference schedule?
Yes, I can. I think that it is very comprehensive. It deals with all major issues connected with the contemporary challenges and problems in the sphere of international commercial arbitration and investment arbitration, which is very important. I really appreciate that this conference also faces the issues connected with these important, newly introduced in almost all institutional rules, services such like mediation, the use and the possibilities of technology in international commercial arbitration. It deals with a specific arbitration in the sphere of energy infrastructure, which is extremely important for Europe, and in line of all the events happened now regarding the Energy Charter Treaty, regarding the political use of Russia, of gas supplies as one of the weapon against the democratic community. So everything influencing arbitration now is in the agenda. And as far as I know, the organizers and sponsors succeeded in inviting and having nice speakers all over the world, both being the Eastern European, Western European lawyers with common law and continental law background.
Mm-hmm. I got the schedule here with me, and you will be moderating the panel titled New Reality, States Responsibility, International Public Law and Dispute Resolution. Could you please tell us a little bit more about its content?
Yes, I will tell you a little bit more because I want to keep certain surprises and to keep this discussion being of a certain effect to the audience. But the idea is to speak about the mixture of the challenges which happened in this field, maybe those which were growing for some period of time inside the system of international public law and investment dispute resolution and came into effect and became the topic of the discussions in the United Nations commissions and centralias and within the biggest centers for the considering of an investment arbitration claims. But all this process were seriously influenced in emergency manner by the war and the new necessity to reconsider the concept of state immunity, the responsibility of the states of their improper acts. And for example, it was very interesting discussion during the ICA Congress in Edinburgh regarding the articles of state responsibility and what are going to be behind them, whether their interpretation could be enlarged or influenced by the current situation. So this panel, which is in a certain extent like an opening of the discussions for some other panelists further during the conference, because some of the topics are related to these issues, should deal with mainly these interactivities and inter-influence of these challenges.
Mm-hmm. So I understand that panelists should expect challenging questions,
yes,
both from you and from the audience. Okay.
Yes. Yes.
Okay, Mr. Yamka, one of the speaker, was my guest on this vlog 2 weeks ago. If there's anything you would like to nail him with as the moderator of this panel, you can tell me, and I won't tell him until the recording is published.
Yeah. What I can say that I'm really glad to have him on board. He is distinguished panelist, and his experience and his participation in the work of the anti-trial commissions is a big and good advantage for our discussion. And what I can say only that the topic he will present and ask the audience to consider the issues dealing with this particular topic is one of the core issues for the discussion in principle. So one of the core topics being the matter of further questions and deliberations.
Okay. All of this sounds really interesting to me because I'm an international law lawyer. But let's talk about the influence of Russian aggression on Ukrainian lawyers. Words probably don't mean much these days, but let me express my solidarity. Of course, let me express my solidarity with Ukrainian academics, judges, attorneys, arbitrators. Please tell our viewers, if you can, how the war has affected academic and professional life in Ukraine.
Seriously, and like many other people, so I do believe that there is not any in these situations, there were no any difference what profession do the person has, because does the person have, because what actually happens that many judges, many lawyers, many advocates and professionals, the very first days appeared in the military service, they applied for that, or they appeared to join the specific territorial military service organized in the cities all over the Ukraine. And it's not only the judges of the district courts, but also of the Supreme Court of Ukraine. One of my very old friends and colleagues, who is the judge of the Supreme Court of Ukraine, actually fought in the Ukrainian army for the period of time. till the court returns to the active work, and he was requested to return back to take his duties as a judge and to proceed with his work, professional work there. So we did a lot to assist those our colleagues who appeared during the first months of the war on the occupied territories, whose residences and offices were ruined, and actually they not only were the issue of how to live, but how to survive. So the professional community united very quickly, and we did a lot through the professional organizations and personally, despite take care of our own lawyers. So it was a very specific period, and returning back, I will also again thanks to all our international colleagues, Polish, German, Italian, American, English, etc., who just raised their hands and said that we are ready to assist, take your lawyers for secondment, to help with the necessary equipment, etc. So these hasty months were difficult. And during the summer, the professional community more or less returned to the practice. Unfortunately, October appeared to be again a very tough months for the situations, with new bombing all over Ukraine and in Kyiv specifically. But the legal professionals returned to their work all over Ukraine. We did a lot. And I can say that according to the best of my knowledge, and not only within our company, but taking into account the major players of legal professions in Ukraine, so the situation looks that some practices managed to return up to 80, even sometimes 100% work being previously before the war. Definitely some of practices still are less than 30%. And it's also the issue of how to the multi-subject possibility of the law firms to deal with different practices, yes, because for those who are like legal boutiques, they can suffer more seriously. The same is with the legal professionals working as judges, working as the associate professors at the universities. So the year began and the students started their remote learning, and so many of the institutions, the staff were evacuated or continued to work online, and so definitely it's not what we had before, but it's going on.
Mm-hmm. And what about arbitration? What is the current condition of arbitration in Ukraine? For example, how many cases had to be postponed? How many hearings had to be postponed?
The International Commercial Arbitration Court, attached to the Ukrainian Chamber of Commerce and Industry, resumed its work also in summer. It seems to me in June and July. I didn't remember now correctly. Sorry. It resumed its work, and very shortly they adopted the new amendment to the rules to allow everything online. Actually, to file the claim, to communicate. We have these like the second hard material submission, but the initial submission and sending of all the documents now is directly provided by the rules in online version. It was extremely important because, as you know, the post and especially the DHL and or posting abroad is first it was impossible at all, and now it is hardly complicated and lengthy. And that definitely was very important because the practice resumed and the hearing began to appear in the schedule of the International Arbitration Court. And also I, as arbitrator, have already a couple of such hearings, all of them remote, but sometimes the companies and the representatives who are living in Kyiv or located in Kyiv, they have this possibility to visit the court personally virtually and to take part in person. Same with arbitrators. And the period in August and September looks more or less calm, and these in-person hearing appeared more often. In October, again, the situation became worse, and the online hearings are still scheduled and they are moving forward. And the arbitrators in the cases which were like stayed for a moment resume the communication with the parties, and it seriously depends on the situation with each concrete case, which representative, whether they are in a position to continue, whether the parties, the witnesses are ready to participate, because again, many people are now within the military forces.
Mm-hmm. So to my understanding, the number of cases has dropped.
Yes, unfortunately.
Okay, but do you think that arbitration will flourish again after the end of the aggression? What do you think? Why or why not? What are the strengths and weaknesses of arbitration in Ukraine?
I think that it's not even I think, I'm confident that this is like the technical reasons. It's not something being within the professional attitude to arbitration in Ukraine, because even vice versa, this autumn it was the publication of the first in-depth survey of the attitude to international arbitration. It was a questionnaire issued by the independent researcher and the Ukrainian Юридическая практика, and they conducted it within the business circles and among the professionals, asking about the level of confidence, their satisfactions, and their like to say expectations about the international arbitration in Ukraine in principle, and about the activities of the Ukrainian International Arbitration Court. And the majority, and I can say that the big majority, it's something like about 60 up to 80% of the respondents highly appreciated both the arbitration and the activities of International Arbitration Court, either from the business circle and among the professionals. And all of them urge to have more developed system of services, to include mediation, which is already included. We have the mediation rules in our court also being adopted very recently, something a month ago. And we also have the big request to proceed with the possibility of our court to consider investment claims as well, and to think about the expedited rules, etc. So for services being more adopted for the situation we have now in Ukraine. So from my perspective, it justifies that the professional community and business, they are looking forward to use international arbitration, and to use it also mainly in our Ukrainian International Arbitration Court in Kyiv.
Okay, thank you very much. Then our guest was Tatyana Slipachuk from Sayenko Karenko law firm. Once again, thank you for accepting our invitation, and I keep my fingers crossed for the conference. And I wish you all the best of luck.
Thank you, and hope to see you soon in November in Warsaw.
Thank you very much.
Thank you. Bye.
Bye.